A continuación vamos a trasladarlos al otro lado del Atlántico. Tengo a mi izquierda a Rina Pantaloni, a quien ya conocemos de anteriores seminarios. Rina Pantaloni cuenta con una dilatada experiencia en el marco de los derechos de autor. Entre sus tareas principales desarrolladas destaca la de haber sido asesora jurídica del Museo Virtual de Canadá y de las Bibliotecas y Archivos de Canadá. Asimismo, en la actualidad es asesora jurídica del Departamento de Patrimonio del Ministerio de Justicia canadiense, cargo que compagina con sus actividades docentes en la Escuela de Artes de la Universidad de Nueva York. Forma parte, asimismo, del Comité de Asuntos Legales del Consejo Internacional de Museos y, finalmente, se debe destacar que ha sido autora de diversas publicaciones sobre propiedad intelectual y cuestiones de patrimonio. Por favor, Rina, tienes la palabra.
Thank you very much, and thank you to the Ministry of Culture of Spain and the National Library of Spain for having invited me to speak today. I think we've all heard a lot about this Canadian model, so I think it's up to me now to shed some further light on what we've heard from previous experts in the field. And before I do that, though, and before I get into the whole provision that we have in our law concerning the unlocatable owner, as we call it, I do want to bring to everyone's attention here two recent studies. I think one has been alluded to already, but one is quite recent, at least the publication of it is quite recent. The first study is the JISC study in the United Kingdom that was published in 2009. I think the author was Naomi Korn of that study that really highlighted the extent of the problem, at least from the UK perspective. The other is a paper that was written by a speaker that will be speaking this afternoon, Dr. Tilman Luder of the European Commission, whose paper was published last week as part of the Fordham Law School International Intellectual Property Law and Policy Conference that is held by Fordham every year, and I think it's an excellent survey of all of the possible solutions for this particular issue. So on to the Canadian model. What we have to deal with first when dealing with Canada is to talk about context. I think our representative from CopyDan, who I think has now left for his flight, alluded to the fact that if you don't talk about context when you talk about possible solutions to orphan works, you may have not obtained the entire story or understand the entire solution. Canada's legal system is based on a hybrid or merger between the civilist approach, where there is a civil code, as you would find in most continental European countries, and the common law approach to law, which is a United Kingdom-based law on precedent and case decision. The distinction sometimes is not so great, but when you're talking about intellectual property law, the distinctions can be quite considerable. When we talk about copyright theory in Canada, we're talking about a system that, while is based on an economic benefit and not a natural right, the courts have come a long way in accepting the fact that we are trying to merge the rights of authors, or as we say in French, the droit d'auteur system, with that of economic benefit and a balancing of interests. And we even have case law that has alluded to this and affirmed this approach to copyright theory in Canada. And I think when we talk about the orphan works solution in Canada, we start to see how this merger, contextual merger, application of copyright theory starts to really play out. What you have on the screen before you right now is simply a quotation from not so recent a decision, but one that is within the contemporary environment where we were dealing with Canada's what we call database decision. And really, it is an affirmation that we are trying to merge the two approaches to copyright. The intrinsic issue or underlying factor in the Canadian system is to achieve balance. Our system, in that way, relies heavily on the collective administration of copyright and on the regulated collective administration of copyright. And as well, there are additional factors which include exceptions specifically for libraries, archives, and museums. This exception, I don't think, is one that is widely available in civil countries in the same way. You can see aspects of it in other common law countries, but you don't have sort of the same packaging as we do in Canada. And it needs to be highlighted in the context of orphan works, particularly for collecting institutions such as libraries, archives, and museums, because you, in my opinion, cannot read the unlocatable owner provision in Section 77 of our law and understand its full breadth and scope unless you contextualize it or read it together with the exception provision. What the exception does is it allows libraries, archives, and museums to make a reproduction of an entire work for the purposes of maintaining and managing its collection, so long as that work is not commercially available in the marketplace. What that means then is, aside from exhibition, if you have a deteriorating work, if you need to create access copies or a copy, that tool is available to you. The issue is one that surpasses a requirement to determine whether or not a work, for example, is in the public domain, because the context here is exception to copyright. We also have something called the defense of fair dealing. My colleagues in the United Kingdom understand this concept very well, because our fair dealing provision was created on the back of the UK provision. There is a provision in the United States that is somewhat similar. What makes this defense very interesting, though, is what the Supreme Court in Canada had to say about it. The whole idea here is that certain uses of works can be considered fair, notwithstanding the fact that they're still copyright protected, if certain circumstances apply. In the United States, you often hear the discussion surrounding 4 factors to determine whether or not a use is fair in their context. In ours, there are a number of factors to consider, but what the Supreme Court of Canada determined there, particularly in the case of libraries, is that there are certain users' rights that have been incorporated into the concept of fair dealing, which is a context or a notion that I think you don't hear often when discussing copyright law. In addition to that, the case really was all about library use for the benefit of patrons, and provided that a use or a dealing was fair even when an entire work had been reproduced and had been transmitted electronically from point to point. Included with that whole context of fair dealing and the exceptions to maintain and manage a collection, and for the collective administration of copyright, there is, in addition, the Copyright Board. It is an administrative tribunal that sets tariffs and approves licensing agreements based on the entire regulatory system. In other words, if you have a license and you are providing that license as a blanket license would be by a collective society, the tariffs are set by the board. And so it is on that basis that Canada's unlocatable owner provision had been created. So what is this Canadian model or provision? Basically, it is a provision that provides that where an owner of copyright protected material cannot be located, the prospective user can apply to the Copyright Board, that's the administrative tribunal that sets tariffs, for a license for the intended use. The license, based on evidence of due diligence, will be granted by the board for a fee, and the fee is paid to the board and is held in trust for a certain period of time. I think the standard in Canada is 5 years. Now, what you don't see on the slide is that the administration of the trust is managed by the collective society that is responsible for the particular purpose of use and for the genre of work. And so it is a system that is entirely based on Canada's regulation of copyright law. There are presumptions and limitations, however. It only applies to works that have been published. So when we're talking about orphan works, this becomes a little bit problematic. I think it was Trevor Clark that mentioned this morning that only 10% of orphan works are those where the owner is known to the user. So what we have in this situation is that it is a provision that may be of use to libraries working with collections where the author or owner, the publisher, is no longer available to provide consent to reproduction. But in the context of archives, of special collections, of museums, this provision becomes less useful because the concept of publication is one that provides a certain barrier. As well, the whole notion of what constitutes publication becomes much more problematic when you're dealing with different genre of work. For example, when we're dealing with literary works, the concept of publication is well known. When you're dealing with photographs, for example, or artistic works, multimedia works, film, this concept of publication becomes much more diluted. I teach at New York University, and I teach graduate students who will become future film archivists. And we host an annual conference called Orphans. And it is specifically designed to exhibit and discuss film where the provenance is absolutely unknown to the viewer, to the collector. And it is remarkable just the extent of these collections that are available, particularly with 20th century works that are not literary. The provision also requires a certain measure of time and fortitude to enter into the administrative law process and make an application before the Copyright Board. I'd like to think that my colleagues at the board are efficient and quick, but every administrative tribunal, any application process does take its time and it takes effort. And it takes effort also to document exactly what may be required of the board in terms of due diligence and to provide the evidence of due diligence. And so it is not a quick fix solution. It presumes some financial value in the work at issue. The whole idea with Section 77 is that a fee must be paid into the board to obtain the license. In many circumstances, how the fixing of the fee can be tabulated and determined is one that I'm sure provides great consternation to the board members. It's very hard to determine how a work that may be previously unknown, even if meeting the publication requirement, can be valued. And this is an extremely sensitive issue. And then, of course, as Tilman Luder alludes in his paper and has been mentioned by previous speakers this morning, there is this whole issue of jurisdiction. Canada's Copyright Board only has jurisdiction in Canada. We cannot apply our laws extraterritorially, and so the result is that the license granted is only valid in Canada. So we've heard that many of the licenses granted under this provision are for analog works. Well, you know, this provision's been in our law since 1988, so it predates the internet. But as you can well see, if your license is only valid in Canada, chances are you're only going to be applying for it in cases where you are dealing with analog works, because if you intend to in any way distribute over the internet, this license isn't going to work for you. You cannot simply place, or you can, but you take some risk in placing any work on the internet where your license is only valid in the jurisdiction of Canada. At the same time, Section 77 does achieve a certain balance. First of all, it's consistent, and it has been stated to be consistent with the Berne Convention in not creating barriers to perfecting copyright protection. It has been stated previously that exceptions to allow for the reproduction and distribution of orphan works can be problematic because somehow you start to validate this whole idea of abandonment. This is not a concept that's consistent with copyright law. You are not seen to have abandoned your rights simply because you're not exercising them or taking steps to protect them. It is not an exception that denies authors rights in copyright, and it's consistent in supporting the system of collective administration of copyright. So finally, to place the unlocatable owner provision in context, really it is you have to work through the Canadian system. So the first question, of course, is the work in the public domain? If the answer is it's in the public domain, then you can go ahead and do what you want with it. If the answer is no, then you have to go to the next step, and does the work and the purpose of use fall under the exceptions provision to maintain and manage? If your purpose in Canada falls within your definition, and by you, I mean libraries, archives, and museums, as they define, maintain, and manage, and it is not commercially available in the marketplace, then you likely can make a reproduction of that work, and you don't have to go to the unlocatable owner provision. If the answer is no, then you go on to the next step. Does the type of work and its prescribed use fall under Canada's fair dealing? If you fall within the factors, and they're usually in the context of research and private study, criticism, commentary, and news reporting, if that's your purpose, then likely you can use the self-help mechanism of fair dealing and hope that you're not challenged, and if you are challenged, hope you're right. But if you don't think you fall within the context of fair dealing, then you have to go to the unlocatable owner provision, and then you have to ask yourself, do I even meet the threshold? Am I dealing with a published work? And if I am dealing with a published work, do I have enough documented evidence that really can truly prove that the owner is not locatable? And if I do, then I can apply to the board. As a last note, I was trolling around the internet because I could not, if you can believe, as part of the Canadian Department of Justice, get good qualitative information, let alone quantitative information, as to how many applications have gone before the board under Section 77, how useful have users found Section 77 to be. In the blogosphere, I found a statistic that I thought was a little bit troublesome. And we've had this provision in our law since 1988, and according to the blogs, only 217 applications have been made under Section 77 thus far. So my hope is that whichever jurisdiction decides to adopt the Canadian approach, that it be adopted in such a way and with such mechanisms that allow for its broadening. Those are my comments, and if anyone has any questions, please feel free to approach me after the session. Thank you very much.